My Lords, I appear with Mr. Citron for the appellant. The respondent is unrepresented. The sole issue for determination in this appeal is whether the 2006 agreement, which my Lords will find at page 188, constituted Greenfield as agent for the appellants.
Pause a second. I think there's a problem with Pause for a second while we get the correct laptop for Lord Hampden. I'm so sorry. Before you make submissions, there are two matters which the board would wish to raise with you. The first is, this is an unusual case where the respondent is not appearing to defend the judgment of the Court of Appeal. Can you enlighten the board to any extent as to why that is the case?
We have no communication. We had no communication from them. They were served with all the proceedings. They did appear in the proceedings in the in the registrar's court to settle the record, the record for the judicial committee, and that was the last we heard of them. From the time the matter was filed, they were served.
They were served with the notice of appeal.
They were served with every other document, and they were also copied on the emails from the registry, the Privy Council registry, and so on.
This is so they have received the record, your written case, everything.
Yes,
as far
everything.
As you know.
Electronic bundle as well.
I mean, are they in liquidation, or do you know?
We're not aware.
You simply don't know.
We don't.
The second point is the circumstance of the production of the key documents bundle. Yeah. According to the board's rules, the key documents bundle is to be lodged 4 weeks before the hearing. When was it delivered to? When was it delivered to couriers to send to London?
It was mailed on the 3rd of May.
The 3rd of May?
Yes. And we were assured it would have been from UPS, that it would have been arrived in 3 working days, which was Wednesday. And we contacted them again. They said they had a delay, and it would have reached by Friday, and which it did not.
Well, they arrived yesterday.
Yes, we.
Yes, but why were they sent? Was the document sent so late? When the board's rules are quite clear that the document is to be in the hands of the board 4 weeks before the hearing.
The case, the appellant's case was filed later than it ought to have been filed, because there were some concerns in respect of the third appellant. I believe it's Frederick Donowa, who was separately represented in the court below, in the Court of Appeal. And his attorney in the Court of Appeal had written to the registry and indicated that they would want to make submissions and so on. So we had to sort out, resolve that issue in terms of the representation. As it turned out, they allowed us to proceed with representation of all the appellants. So that issue was resolved a bit later and caused some delay in the filing of the case. So, and thereafter, everything else after that followed, the electronic bundle and the key documents bundle.
We've had the electronic bundle for a while.
Yes.
But it was the key documents bundle. When was it agreed that all the appellants would have the same representation?
It would probably be about a week before the case was filed, or so.
A week before the electronic case was filed?
Yes, yes.
Yes, and can you remember the date on which the electronic case was filed?
I can just a moment. It was filed on the 1st of April.
On
It was filed on the 1st of April.
the 1st of April?
Yes.
So by the 1st of April, you had an agreement that all the appellants would have joint representation.
Yes.
Well, I have to ask the question again. Why did it take to the 3rd of May for the appellants to send or give to UPS the key documents bundle? Because the rules are quite clear on this.
We respectfully apologize for that, but I believe it was filed shortly after the electronic bundle was filed. The electronic bundle was filed on the 15th of May.
Well, I don't think I should detain you, but I would like a short note setting out when the problem of joint representation was resolved, when the electronic bundle was sent, and we know from your statement that this morning that UPS were given the key documents bundle 10 days ago. And the board is requesting a short explanation as to why that there was non-compliance with the 4-week deadline, because it has put the registry staff to quite a lot of bother trying to find out where this bundle was. And the board does expect its rules and practice notes to be complied with. Yes. Thank you. I'll let you develop your submissions now.
Thank you. My Lords, the sole issue for determination is whether the 2006 agreement, which it is referred to in our case, the 2006 development agreement, which is at page 188, constituted Greenfield as agent for the appellants. The task, the court's task is set out in the Ocean Neptune case, which is the authorities tab 5.
Do you have an electronic page number?
Yes. Four 404.
404?
Yes.
Yes, thank you.
Yes, and the court's task, where it says the court's task is to ascertain the objective meaning of the language which the parties have chosen in which to express their agreement. The court must consider the language used and ascertain what a reasonable person that is a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant.
I don't think this says anything different to Wood and Capita, does it?
Pardon?
This passage says nothing different to what the principle set out in Wood and Capita.
No.
No.
No, it is a summary of, as we see in paragraph 8, Mr. Justice Popplewell refers to various earlier cases, including Rainy Sky, Arnold and Britain and Wood and Capita, and they are often the cases that are cited in the courts on statutory interpretation. And I think you can take it that the board is familiar with these matters.
Yes. I just want to point out one part of that.
Of course.
Because it directly deals with the submission that I will make, and that deals with the business common sense aspect. So it says if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other.
Yes.
And in that regard, I would just like to refer the board to the Arnold and Britain case at page 331, paragraphs 17 and 19, where the court cautioned basically the use of invoking the commercial common sense principle in a situation where the words themselves, where the meaning can be ascertained from the clauses in the contracts themselves. And the reason I draw the board's attention to that, it is our position that this is not the type of case in which it is necessary to invoke the business common sense aspect of the interpretation. But that even if you do, it still supports the appellant's case. Now, I would also refer to paragraph 21 of that same case, Arnold and Britain, at page 332. The fifth limb as set out in Arnold.
Which paragraph?
21. That's at page 332.
Thank you.
And the fifth limb, which says you have to consider the facts and circumstances which existed at the time of the contract, which were known or reasonably available to the parties, meaning the parties to the contract. Now, this case, we are submitting, my lords, this case is somewhat a bit unusual. The reason for that is that we have the respondent, you have Donridge Limited, they are contending that a certain interpretation should be applied to that to the 2006 agreement, but they were not parties to the 2006 agreement. And most of the authorities, the dispute amongst interpretation of the contract and facts known to the parties and so on are between parties to the contract.
Why does that make a difference if the test is objective?
Because insofar as the court has to consider the facts that may have been known or ought to have been known to the parties at the time of the contract, there is no evidence from Greenfield Limited, and those are matters on which the Donridge Heights Limited, the respondent, are not able to deal with because they weren't parties to that agreement. But they came in the picture subsequent to that agreement.
But again, it's not the task of the board to work out what the factual matrix was. We have the Court of Appeal sets out a paragraph 44 of its judgment at electronic 284 what it considers to be the background information which would be available to the reasonable person in the shoes of the parties. Do you agree with that statement?
Not insofar as the Court of Appeal states that the payment for the land was supposed to have been derived solely from the sale of parcels. Indeed, in addressing the background, the Court of Appeal made an assumption that all payment for the land was supposed to and intended to come from sale of the parcels. And we are saying that that is not in fact so. In fact, that is inconsistent, as I will demonstrate later on. That is inconsistent with the contract itself.
Yes, but I was asking you not about the contract, but about the background facts.
Yes.
That would be that a reasonable person standing in the shoes of the contracting party would be taken to know. And if you look at page 284, you see there the Court of Appeal expressing a view purely about the background facts, not about the interpretation of the contract itself. And I was wondering if you accepted that as the factual matrix, or if you're wishing to add to it.
No, we are accepting it, save and accept that that part of it.
So the penultimate sentence of paragraph 44, you say that's wrong.
Except that second last sentence, yes.
Yes.
Thank you.
Because in fact he paid $1 million.
Yes, payments already for.
Yeah,
Because the million has already been paid by the developer.
Part of the $1 million was paid.
Part of the $1 million.
I thought it was the whole of the $1 million. I thought it was $250,000 to each of the owners.
Yes, I stand corrected.
Yes.
Yes, was the $1 million, which would be the first tranche of payment, which was only 7 days, to be paid 7 days after the signing of the agreement, at which time, obviously, no sales would have been contemplated.
Thank you.
Or in existence.
Was that the sole amount that was paid
That is the amount that was
to
paid.
your clients?
Yeah, to the appellants, yes.
Well, it was 10% of the $1 million
Yes.
to be paid within 7 days, and 90% within 90 days after various
Yes.
documents were made available. But in fact,
Yes.
the whole $1 million was paid.
Yes, yes.
Yes.
The,
Thank you. That's helpful. So we qualify paragraph 44 by the fact that the $1 million was paid.
yes.
Thank you.
So, another feature of this contract, the 2006 agreement, so far as its interpretation is concerned, that I would like to draw to the attention of the board, is that Greenfield did not file a defense to the claim in its original state. Now, the claim as originally filed, the statement of case as originally filed, had nothing to do with agency. It was a case strictly against Greenfield as the person solely, as the company solely responsible. So it was only subsequently, after getting judgment, default judgment against Greenfield, the case was amended and the appellants were added, and the issue of agency pleaded. Now, the effect,
When did they got judgment in default, did they?
they got judgment in default against Greenfield, but
When was that? You know?
I don't have the.
Were the amendments made after the judgment?
It was before. It was before the amendment.
The judgment was before the
Yes,
amendment?
definitely before the amendment. So the effect of that, I am submitting, is that Greenfield must be taken to have admitted the facts as pleaded in the original contract. The original statement of case, which is that it was not acting as agent for the appellants.
But how is Greenfield's assumed admission relevant to the task of the board here, which is to interpret this contract?
Well, what you have is that the two parties to that 2006 agreement are in effect ad idem on the issue that there was no agency.
But these are actings by one of the parties long after the agreement was entered into. How can we look to those actings as a tool for interpreting the contract?
Yes, I intend to address that because the reason for that is because I have, and my lords would have seen in our written case, that I have set out that the court can look also at the manner in which the contract was administrated and acted upon by all the parties, so that even though you're not supposed, you don't take subsequent matters into account, you can look at the manner in which all parties understood the contract and acted upon it,
But
in inferring what was the intention of the parties.
Was it create an agency or not? Is that
Yes.
the issue?
Yes.
About?
Yes. So our propositions is that the objective analysis, on an objective analysis of the natural and ordinary meaning of the relevant clauses, it does not support a relationship of agency. 1. 2, so there is no need to invoke commercial common sense principles, but even if one is to do that, then it would support that there was no principal-agent relationship. And
Why is that?
well, what I propose to do is to address the board firstly on the natural and ordinary meaning of the terms, and then address the business relationship issues, even and the ones specifically the ones raised by the Court of Appeal.
In relation to whether we can look at the conduct after the agreement,
Yes.
as to whether there was an agency,
Yeah.
what's the authority you rely on there?
I relied on the case of WT Lamb and Sons. It was inadvertently omitted from the bundle, but I did send it by.
We've received it as a supplementary document.
Yes, and that's where Greer LG, in my opinion, therefore, it is not necessary to consider how this contract was acted on in practice.
We're reading from which page of the electronic document?
I'm reading from the appellant's case,
It's page
in which
6.
we have quoted, yes.
Page 6 of the report, right-hand column.
Yes, I see the passage. Yes.
Yes, so we're saying that if there is an ambiguity, then the court can look at how the contract was acted on in practice.
But other than the developer's behaviour in the context of litigation, are there other things which you can refer us to more directly relating to how the contract was acted upon, on which you're founding?
Yes, so in terms of the manner in which the contract was acted upon by the parties, and when I say parties, I mean not only the parties to the 2006 agreement, I am also referring to the respondent. So, firstly, we have the 2008 sale agreements between Greenfield and the respondent. Greenfield does not hold itself out as being expressly or impliedly acting as an agent of the appellants.
Yes, and your point is there's no suggestion in the 2008 agreement of any agency.
Yes. Secondly, there is no contemporaneous documentation in which Greenfield holds itself out as agent, whether cash receipts, letters, or otherwise.
This is paragraph 26 of your case, yes?
Yes. Thirdly, the respondent has not in any correspondence written to Greenfield as agent of the appellants, and neither has Greenfield written to the respondent in any capacity as agent of the appellants or otherwise assumed such a title. And I referred to DC 6 in the witness statement of Deborah Cumberbatch on behalf of Greenfield. DC 6, DC 8, DC 9, and DC 10.
So what page numbers are they?
Those would be at EB1,
Sorry?
page 192.
192.
Yes. DC 4 is at 192, and 4, DC 9.
So, what are we looking at here?
These are all correspondences, correspondence emanating from the, just a moment, from the respondent. So if you look at firstly at DC 6,
So what page is that?
DC 6 is on page 210.
Thank you.
You will see Donridge Heights Limited is writing on the 29th October 2008, the project managers, Greenfield Properties Limited. There's no issue here on behalf of any of the, as agent. And note in all of these correspondences, I will take the board to, not one single correspondence has been sent to
How far can the board now look at the primary material when there have been findings of fact? And how far are we entitled to look at this afresh?
well,
We're not judging this at first instance.
yes, right.
But your point is, and that there is, your point is that there is nothing in the correspondence
Yes.
to show that the developer held itself out as an agent.
Yes.
And I don't think there's anything in the findings of fact to suggest they did. That's probably sufficient for your purposes.
Very well. Right.
If you wish to give us the references to the various documents, the board's happy to note them down. But I think, as far as I can recall from the Court of Appeal's judgment, there was no suggestion that the developer ever held itself out as an agent. And that's the point that you're wishing to establish.
Yes. So those references would be DC6, DC8, DC9, and DC10.
If you just give us the electronic page numbers, please, because we only have them in electronic form.
So the DC6 is page 210.
Yeah.
You got that one?
DC8 is page 212.
Thank you.
DC9 is page 215. And DC10, page 216.
Okay.
And then you have the respondent. So what we have after that, in addition to that, we also have an admission. What we say is an admission from the respondent, because the respondent has accepted at paragraphs 15, 16, and 17, and 19 in its pleaded case.
15, 16.
15, 16, 17, and 19 in its pleaded case, and in the witness statement of Deborah Cumberbatch.
And what's the electronic page number for that passage in the pleadings?
(226).
Yeah, so you will find that at page 179. So it's both in the statement of case and in the witness statement. So I'm referring.
Statement of case, I think, is.
Sorry, it's in the statement of case and witness statement.
Well, what does the statement of case say?
226, paragraph 15, if you're following.
Yes. Yes, so it says paragraph from 15 to 19. Donridge has the respondent is essentially saying that there were several meetings being held in that period in which they were trying to get Greenfield to relinquish control. And we say that the effect of that is an admission that Greenfield was actually in control, because they didn't go to the appellants and say, look, fire your agent, fire Greenfield, and let us take over the project. They were trying to get Greenfield to agree to relinquish control of the project. And we say that it's to be construed as an admission.
I mean, the slight difficulty with that is that paragraph 19 alleges that the first defendant as servant and or agent of the second to fifth defendants breached the contract. So, as part of the same pleading, they are asserting that Greenfield was the agent.
And that's part of the original pleading, isn't it? It's not underlined in red.
Yes, this would have been amended. That is part of the amendment.
What is it?
But
Is that part of the amendment? It's not underlined,
No.
whereas other
Yes.
sections are.
it's amended.
It is, that's a mistake.
Yes. No. The amendments are in red, and the deletions are crossed out. So the amendments are not underlined in our jurisdiction. They're just simply put in red.
So, but the original proceedings were just against the developer.
Yes, correct.
Then later,
Yes.
the appellants were added as parties.
Yes, yes. But irrespective of the amendment, what I'm saying is that paragraph 19 sets out how they are saying what are the particulars of breach. So they are saying that the defendant, the appellants were agents in that paragraph. But from 15 to 18, where they are setting out the factual circumstances, they are essentially admitting that they understood that Greenfield had control of the project, and they had to get an agreement with Greenfield to step down and relinquish control of that project. And then they move
I'm
on.
not sure how much we can take for this. Certainly looking at Ms. Cumberbatch's statement,
Yes.
which was lodged on the 8th of August, in paragraph 20 at page 180, which this is presumably before amendment. At that stage, the assertion being made was that the first defendant was servant or agent of the second, third, fourth, fifth defendants. So I wonder if there's much we can take from the pleadings.
Yes, I accept that that is pleaded, but the basis for that has not. They have a pleading
But
in which this.
you were saying to us earlier that there
Yes.
was an admission that they were not agents. Now,
Yes.
that cannot be said standing these pleadings. But what you're saying is that there was an admission of facts which objectively
Yes.
were inconsistent with agency.
Yes.
Thank you.
All right.
Can I just say this, that the submissions you're making now
Yes.
go to a point which one might have thought was really the bull point in the case, namely whether Greenfield entered into the 2008 agreement as principal or as agent.
Yes.
Because unless it entered into the agreement as agent, then the respondent had no claim against your clients. But the issue, as stated in the statement of facts and issues, and this is the way it was argued, I think, in the courts below, was whether the 2006 agreement
Yes.
is to be construed as conferring agency on Greenfield, or whether it was a contract of sale.
Yes.
So that's, I mean, if one directs oneself to that issue, at the moment I can't really see how what happens in the action and in relation to the 2008 agreement is at any rate directly relevant to that.
Yes. Well, insofar as I indicated, I referred to the H.T. Lamb and Sons case, that insofar as it may be relevant to look at how the contract was acted on in practice, then these are the matters that would arise.
The difficulty there is that what you're pointing to is what was happening as between Greenfield
Yes.
and the respondent,
Yes.
not what was happening as between Greenfield and the appellant.
Yes. But I accept that, but it's the claim. The claim was Donridge Hyde's claim, the respondent's claim. And what I'm saying is that in those paragraphs, they are in fact admitting factually that they understood Greenfield to be in control of the project.
Well,
But is there more?
So and if what I'm looking at is how the parties acted on the agreement in practice.
Isn't it more useful just to look at the actual agreement itself to see who was in control?
Yes.
And because you don't need this point if you can demonstrate that Greenfield was in control of the development.
Certainly, and that is why I intended to address this point.
Yeah.
Lastly, as an alternative, and to the extent that the board feel it is able to take these matters into account,
Yeah.
then these would be the subsequent matters that would be relevant. If the board is of the view that it can look at the way in which the contract was acted upon in practice. But the crux of my submissions is really on the natural and ordinary meaning of the contract, reasonably, objectively.
The primary submission is that
Yes.
a proper reading of the contract gives
Yes.
the answer.
Yes.
If there is ambiguity, you
Yes.
invite us to look at subsequent actings.
Yes,
Yes.
that is correct.
Thank you.
So I just want to go to the contract itself. Particular features of the contract. And the first is the issue of the developer under the terms of the contract. Well, the developer is the one, Greenfield, had the power to control the project in its entirety, and more particularly including fixing the sale price. And we say that this is a critical factor in that determination, and I referred to Re Neville and
When
my
you say
lord.
the sale price, you mean the sub-sale prices?
Yes.
Yeah.
To for the parcels to the sold to the respondents or to third-party purchasers. Yes, and that way you will find that at page 421 in Neville, Re Neville, and it says if he sells at the price at which he is authorized by his principal to sell, and upon the credit of it which he is authorized by his principal to give, and the customer pays him according to his contract.
So where are you reading from? I'm so sorry.
And the this is in Re Neville,
Yeah. 421 I'm on.
yeah, page 421.
And whereabouts are we on the page? Do we start with Sir George Mellish's judgment?
No, just a moment.
Is it right-hand column, page
Yes.
421?
It's on the right-hand column. I'm just looking to see where it begins. Yes, so
It's the last sort of 10 lines, isn't it, on the right-hand column?
yeah,
If the consignee is at liberty, is it that part? To sell at any price he likes,
yes,
but to pay a fixed price to the consignor,
Yeah.
their relationship is not that of principal and agent.
yes,
Yeah.
Is that the passage that you're wishing to refer us to?
yes.
Thank you.
And it's also quoted in the submissions in the case for the appellant. At paragraph 16.
My understanding is that Greenfield can not only sell at whatever price they thought was appropriate,
Sorry, paragraph 18.
whatever price was appropriate, but on whatever terms.
Yes.
So they could have it as by way of a long lease or a short lease or a lease containing particular terms or service charges or whatever.
Yes.
So they were in charge not only of the sale price,
Yes.
but of the terms upon which
Of the
was-
terms of the lease. They had absolute control over that. Yes. And then the other issue is the developer, Greenfield, had the unrestricted power to alter and change the character of the land with wide discretion in the manner in which this was to be done. And I say that because the developer's obligations are devoid of any specificity in the manner of how the land was to be developed. That is to say, things like scope of works, cost and technical reports, etc. And again, Sir Mellish LJ says in this regard, and this is at paragraph 19 of the case.
If you could actually find it in the authority, it would be helpful.
Yes, it's 18. It's at page 4, electronic bundle 422.
422, and which column?
Oh, it's about 10 lines down the left column, but if in addition to this he is allowed to change the character of the goods?
Yes. Yeah.
Thank you.
Yes, so we say that that is another distinguishing feature.
Not only, as I understand it, is the developer able to dictate the terms on which the property is sold,
Yes,
and the method, what title is given,
yes,
but also the developer is able to dictate that any, for instance, freehold that was left would be assigned to a service company.
yes,
So was able to control the freehold,
yes,
and also the by asking for it to be assigned to a nominee.
correct. And in essence, the Greenfield was running a business operation of its own. He had the decision to make, for example, how wide the roads, what type of material he's using on the roads and so on, to make a profit for himself. Fix the sale price and so on. It was like running an enterprise on his own. So it's, as I said, it has nothing in relation to the specifics of what development, what actually is to be done. If you have to put in drains, how much feet of drains, how wide the drains are to be, and so on.
Yes, I mean,
That was totally.
your point is that when you read paragraph 3 of the agreement
Yes.
about subdividing the parcel, conceptualizing a development plan,
Yes.
getting approvals for the designs for phase 1, executing the works, the appellants were given no control over any of these things.
Correct.
That's the point, I think,
Yes.
that you take from the contract.
Yes.
Yes, I see that.
And
And then also entering into sale agreements. That again, you say that the developer was left to do what it wished to do at its discretion.
to make a profit as opposed to a commission. So he was not being paid a commission of the sale price, which I'll come to later, but he was actually being paid. He had to make a profit in order to get money, which is uncharacteristic of an agent. An agent will normally be paid a commission of the sale price.
Yes, well, as I understand clause 5, the developer gets a development fee, a percentage of the total
Yes.
project cost, and a share of the profits.
Yes. So if you look at item 6 of the 2006 agreement, clause 6, and that is under the heading, I think that's page 331. It's under the heading payment framework. And this part outlines a comprehensive payment scheme which places an obligation on the greenfield to pay the landowner 10% of the initial payment of $1 million within 7 days of the date, long before any developed land could possibly be sold or contemplated to be sold, because this was in a very early stage of the arrangement. And also the balance of 90% within 90 days of the instruments referred into 2B, which was also contemplated to be in the early stages. And if you look at clause 6A and 6B, they were designed to give effect to the developer's obligation to pay the full market value for the land, pursuant to clause 4, bulleted point 1.
Could you explain in 6B, it talks about 5 half-yearly installments of the balance of the purchase price due to the owners on the value of phase 1. Are we to interpret that simply as the undeveloped value of phase 1? It's the value of the site.
Yes.
So you get the $1 million, and then you get the residue of what was envisaged as an agreed price, an
Yes.
agreed market value.
Yes.
Is that how we are to read this?
So 6, yes, so you have an initial payment of 1 million. You have 10% within 7 days. Then you have the balance within 90 days after you got the instruments. And then 5 equal half-yearly payments of the next 2.5 years, representing the agreed balance of the purchase price. So that ties in with clause 4, which gives the formula by which you're going to ascertain the market value.
Okay, can I just ask, I think it follows from what you said earlier, but I'd just like confirmation that none of those 5 equal half-yearly payments were in fact made?
No,
They weren't?
they were not. Yes.
Can you remind the board, what was there in fact an agreed market value fixed?
It was not fixed, but it could have been ascertained from the contract.
Yes, one could clearly jointly instruct a valuer to tell what the value was,
Yeah.
but that in fact wasn't done. So the 5 half-yearly payments were never paid.
No.
Yes.
And I think it never reached that stage because this was signed in 2006, and by 2008 there were problems and Greenfield disappeared, claiming he didn't get the instruments. They claimed they didn't get the instruments and so on. So what I'm saying is there was a fixed price because although there's not a figure, it was to be ascertained by means provided for in the contract, and that is at clause 4.
And is the board to take it that you found on the words in 6B that what we're dealing with is the purchase of at least the beneficial interest in the land by the developers?
Yes, correct. So what we've basically submitted is that you have a standard sort of development arrangement where you don't really transfer the title to the purchaser, and then the purchaser sells to his purchasers, because what you incur in unnecessarily substantial expenditure by doing that in respect of stamp duties and so on. So you would find that the purchaser, which is Greenfield in this case, would use his authority under the contract to assign or to have the landowners transfer directly to the end purchasers. So you avoid that additional substantial cost of the stamp duties.
And there was no relief for subsales under the stamp duty legislation, is that right?
Pardon me?
There was no subsale relief under the stamp duty legislation.
Yeah, so if you do it in that way, only the end purchaser pays for their lot.
Yeah.
Yes, but Greenfield would have avoided for the entire.
Yes.
Yeah, so, and in respect of that, I refer to that type of payment obligation where you have someone paying before or committed to pay before you have monies coming in is not characteristic of a principal-agent relationship. And in this regard, I refer to Wayner v. Harris, and that is at page 437. And it is at page 408 of the judgment itself, bundle number 437.
So, what page, sorry?
Page 437 of the bundle,
Yes.
but it's page 408 of the judgment.
Sorry,
I'm getting lost.
Where it starts with, "This is plainly, as it seems to me, a transaction which Fisher had no right to buy."
sorry.
What electronic page are you on?
That would be page 437.
437, and on the, where are you reading from on that page?
7th line.
So what's the passage you're referring to again?
Yeah, "This is plainly, as it seems to me."
Oh, I see. It's about 7 lines down.
Yes. "A transaction in which Fisher had no right to buy. Fisher only had a duty towards Wayner to sell, and he was to be remunerated for his services in selling the goods by half the excess of the cost price, no more. It is all the more extraordinary because he was not even accountable to Wayner for the so-called purchase price. That is to say, the cost price plus half the sale price, until he actually received money from the buyer. I do not say the ultimate buyer, because I do not consider that he was the ultimate buyer."
What are we to take? I mean, this is presumably a description of a particular contract.
Yeah.
Yes.
What are you asking us to take from Wiener and Harris in terms of principle?
Because if he having no obligation to pay the purchase price and to be accountable for the purchase price, he was held not to be, he could not be a buyer. I think in this case it was sale or return was the issue. So the words used in this case was sale or return. And what the court was in essence saying is the words you describe the transaction by is irrelevant. When we look at the terms of the contract, you had no obligation to pay the purchase price. And it's very uncharacteristic for an agent, a commissioned agent or an agent, to be taking money from their own pockets and paying to as the owner in this case, or if it's a vendor in the case of goods, before any sales monies are received from sales and so on. I go on now. Further, Greenfield was liable under the terms of the agreement to pay a fixed and ascertainable sum for the land, and I had already referred the board to clause 4.1. This sum was to be the market value of the land in its undeveloped condition. And the authority I referred to there is the W.T. Lamb and Sons, which I referred to earlier. But in this particular instance, I referred to it for the proposition that there was in this contract a fixed price, even though that there was not a money figure on the contract. It was ascertainable by means provided for in the contract. The fixed and ascertainable...
So just make sure I've understood. What you're saying is that clause 4, first bullet point,
Yes.
what was indicative of a contract
Yes.
for sale at an ascertainable price.
At an ascertainable price.
Yes, thank you.
And then the fixed and we are submitting the fixed and ascertainable price of the land was in actuality the base price of the land. So what you had was two components. You had the price of the land, and then you had I refer to it as potential compensation. That was in relation to the 45-55% sharing of profits. Now, why I say potential compensation is that is compensation which may or may not materialize, because that compensation is premised on the basis of a profit being made. So if, for example, the Greenfield ran into losses, or or there was a break-even situation, so no profits, then that part doesn't kick in. He's not liable to the appellants for anything. But that doesn't change the fact whether he made a profit or not. That doesn't change the fact he remained liable for the market value of the land.
Yes, so it's the combination of the first bullet point of 4
Yes.
and 6b, where it talks about the purchase price.
Yes.
You say this is properly construed as a sale of the
Correct.
land
Yes.
to the developer.
Yes. And insofar as the evidence of the appellant is concerned, Maria Donowa in her statement says this was done because of the length of time that he was paying off for this land. This was supposed to be like sort of a bonus for that the arrangement.
So what was the bonus? The 55%?
The 45%, yes, because he was going to, it was anticipated that this payment wasn't going to be in a lump sum. It was going to be in a period, over a period of years or so on. It was additional sweetener, and so to speak, to compensate for that fact.
So,
but it was not really part of the sale price, because as I indicated, that is something that may or may not materialize based on whether Greenfield made a profit or not.
If you, the amounts that were paid by the respondent
Yes.
were deposits
Correct.
in relation to contracts of purchase.
Yes.
And as I understand it, what you're saying, there was never any obligation
Yes.
to pay any part of those monies to your clients.
Correct.
Unless there was a profit.
Unless there was a profit.
And then the obligation was only to pay across
Yes.
55% of the net proceeds, net profits.
Yes, and why I say that is because if you look at the formula for how profit is to be calculated as stated in the contract, it says profit was defined as the sales less the expenses on the project, not the cost of the land. So it was strictly Greenfield earning money from the sales, and a calculation as to how much he spent in developing the land, and the difference would account for the profit. It would be otherwise if profit was to also taken to include the price of the land, the market value of the land, but it wasn't. And the contract is very clear on how profit it was defined. So it means that whether he made a profit or not, he remained liable at all material times for the payment of the purchase price under the agreement. And that formula I speak of is at clause 4.2. And you would see it clearly excludes the cost of purchasing the land. And when you ascertain in profit, you are not taking into account the cost of purchasing the land. So purchase of the land is totally independent. The other point is the issue of risk. And we say that Greenfield took all the risk in this project, and there was no risk on the part of the appellants. And the reason for this is whether the project was a success or not, Greenfield remained liable to the landowners for the market value of the land. And so therefore, if the project ran into losses, the appellants were under no obligation to repay Greenfield for any of the project costs for the development works and so on. They were not liable to reimburse them for any money spent or reimburse any of the monies they received from him. And this, we are saying, place the risk associated with the project squarely on Greenfield. And that we are suggesting is inconsistent with an agency. Because in an agency, it is the principal who will bear the risk if something goes wrong with the project or it runs into losses. And then the compensation clauses for Greenfield, that's clause 5.2, provides for the developers to retain 45% of the net profits. And we say that this is inconsistent, also inconsistent with an agency. And I've referred to Bosted and Reynolds on Agency 22nd edition. And you would find that at paragraph page 374.
3?
Yes, 374.
374, thank you.
At paragraph 1-036.
You're looking at Bosted, yes.
And it says the distinction between agent and buyer for resale normally turns on whether the person concerned acts for himself to make such a profit as he can, or is to be remunerated by prearranged commission. And what we are saying is that in this particular case, Greenfield really was obligated to try and use his best efforts if he was to succeed with this project to make a profit for himself. In other words, he had to manage this project in a commercially viable manner to ensure that at the end of the day he made a profit, because if he made no profit, there was no 45% for him, or none at all.
Well, there were two elements to developers' remuneration. There was the development fee,
Yes,
and the profit.
yes,
So there's the development fee in 5 bullet point 1,
yes,
and I think it's mentioned again in 6B, developer shall be entitled to a fee of 10% of the approved value of the work done to date on the project.
Yes. So yes, so while it provides for a development fee, we are saying that it is still manifestly commercially disadvantageous to Greenfield if he did not score a profit, because all he would have, if he ran a loss, he's only getting back 10%
Yes.
of what he recovers. So he was, in effect, for this to work for him, he had to manage this project and make a profit for himself. If he didn't make a net profit, he would run into losses, because even the development fee would have been 10% of what he put out on the development.
So are we to understand that if the development wasn't profitable,
Yes.
The appellants would be liable to pay that 10% development fee, but nothing else?
Nothing else.
Yes.
And I hope I've understood the developers A and B correctly. Although B read on its own says for the work done to date,
Yes.
it doesn't just mean to the date of this agreement,
Yeah.
because it to date appears to be a sort of formula word, meaning during the life of the project, from
Yes.
time to time,
Yes.
in delay.
Yes.
I think it has to mean that in
Yes,
order
yes.
to make
I agree.
5 and 6 compatible.
Yeah.
Yes.
Do I understand you to be accepting that the appellants, as the owners under this agreement, would be liable to pay the 10% fee from their own money?
Well,
Just go into the calculation of net profit.
Yeah.
yes. Well, I would say that would only be applicable if, for example, the contract did not, the contract was terminated. So it was a sort of a
Well, if it was, do you mean by the owners in breach of?
yes. So if for some reason Greenfield could not complete, or there was a breach by the vendor and the contract was terminated, then
Well, I can
So-
understand damages for breach of contract,
Yes.
but supposing the contract is performed in accordance with its terms,
yes,
so that the land is developed,
yes,
sales take place,
yes,
but the total amount raised from the sub-sales is enough only to pay the costs of development and is not enough to pay the 10% fee.
I think
What's
they
the
would,
position then, do you say?
if I think they would have also be liable for the 10% fee.
When you say they would be liable, you mean who?
The appellants,
I see.
yes. And then I refer to, again, same paragraph in both Studs and Reynolds on agency, that,
Just before leaving the 10% fee, come what may, the owners were going to have to pay 10% of whatever the total project costs were.
yes.
Yep.
And again, on both Studs and Reynolds agency, at the same reference, page 374. And it deals here, does a manufacturer may contract not to market his goods through anyone but a particular supplier who is said to be a sole or exclusive agent. If the supplier is on the true construction of the agreement a buyer from the manufacturer may be in breach of contract if he sells the goods himself. But if the supplier is a true agent, the manufacturer will usually be entitled to sell personally as well. And we are saying that if one looks at the terms of this agreement, the 2006 agreement, the appellants could not go and sell these lands once that agreement had been signed in 2006. Had they done so, they would have most certainly been in breach of contract. Now, I just want to look at some of the, deal with this in the context of some of the particular issues raised by the Court of Appeal. And we are saying in this regard that the Court of Appeal placed inordinate weight to matters which were not unequivocally referable to the existence of a relationship of principal and agent. So, for example, the Court of Appeal found that Clause 3F gave an express power to Greenfield to develop and sell lands. But having an express power to do so is not unequivocally referable to a relationship of principal and agent. That power to develop and sell lands could also be referable to other relationships.
Well, is it, in your case, is it a power at all? It's an obligation to do it, and if you're right,
Yes.
that the land has been sold,
Yes.
the beneficial interest has been sold
Yes.
to the developer,
Yes.
then it's the developer's job to try to generate a profit.
Yes.
It's not a power conferred by the vendor.
Right.
It is an obligation
Yes.
further down the line.
Yes. And in any event, in respect of that clause, apart from it being an obligation, we are saying that that this is a clause then that was simply expressing what the law already is, because as the beneficial owner, he had a power to have it conveyed, have the parcel conveyed to himself or to his nominees, as any purchaser would have under standard sale of land agreement. So putting it in writing and saying that he has the power to do so adds nothing to what he already had.
Again, I wonder if you're making life more difficult for yourself than you need to, because if there was the sale to him, he could, with no obligation, he could just sit in his hands and leave it as it was.
Yes.
But because the agreement was that the land would be developed,
Yes.
you had to oblige what you say is the purchaser to get off his hands and do something.
Correct.
So it's an obligation rather than a power.
Yes.
And if this is a sale agreement, there's a very long sort of twilight period between the contract for sale and its ultimate completion by firstly the payment of the whole of the purchase price, including the 55%, which will be years down the line.
Yes, yes.
And the conveyance of the last piece of land by way of sub-sale to sub-purchasers of the buyer.
Yes.
So it's not, you would presumably say, surprising to see the contract spelling out who has to do what during that long twilight period, by contrast with an ordinary contract of sale that's going to be completed in a couple of weeks.
Yes. I accept that. Now, and in this regard, I've referred to the Dalalan Cumbernauld Limited and Sin Properties, CIN Properties Limited, a very extensive judgment. So I sought to include the abstract, and that case is at that authority is at page 399.
Sorry, 399?
Yes. And in effect, what happened in that case really is a landowner leased land to a company. That company developed the land at their own expense and leased it back to the landowner. And and it was contended that there might have been a joint venture. And if the board looks at this summary, the action dismissed as irrelevant, an arrangement under which the owner of a site leased the site to a tenant who provided capital for its development by the owner and sublet the development to the owner in return for a rent, which was partly based on the rents paid by the occupying subtenants, did not amount to a joint venture between owner and the tenant, particularly in the absence of any other indications of partnership. A common economic interest did not itself create a joint venture. So in this particular case, the issue was whether there was a joint venture or not. In the case at bar, the issue is whether you have an agency or not, but we are submitting that a similar principle applies, not because the parties have come together and you have joint exploitation of the land. It necessarily implies that there's a relationship of principal and agent. There could be other relationships as well. For example, a joint venture.
Well, two points. You're citing a first instance decision by the Outer House of the Court of Session.
Yes.
This case, in fact, went to the House of Lords, but that may be by the by. And the second point, would you characterize the arrangement after the sale of the land to the developer as a joint venture? How would you exclude what is being discussed in CIN and Dollar Land, which essentially is assessing whether there was a partnership? As I recall the provisions in Section 4 of the Trinidadian Partnership Act,
Yes.
A sharing of profits
Yes.
in a common business is a prima facie indicator
Yes.
of partnership.
Yes.
But it can be that prima facie understanding can be
Displaced.
overturned by other factors.
Yes.
What do you say the other factors are in this case?
No, well, what I'd say is that the case that was brought by the respondent was grounded solely in principal and agency.
Yes. So you say it's not a case you have to answer.
It's not an issue, but why I look the principle in this case, which I wish to advance to the board, is that irrespective of joint exploitation of the land, you had to look at the agreement. They looked at the agreement itself to discern whether or not there was a joint venture or partnership. You could not just by the fact that they were in a relationship exploiting the land infer from that that there was that relationship. You must look to the agreement itself. And
so if I understand your case, essentially is you look at the agreement,
Yes.
it's a sale with overage, as it were, more payments if the development is successful.
Yes.
And it should be characterised not as a partnership, but as a contract of sale.
Yes.
With this further payment.
Yes.
In the event that the development succeeds.
Yes.
Yes, I see. Thank you.
And the Court of Appeal, at paragraph 49, and we are saying erroneously took into consideration form rather than substance. And in that regard, it looked at the designation of the parties under the contract and the fact that that Greenfield was referred to as a developer. That is, paragraph 49 of the reasons of the court.
The page.
286.
Yes.
Yeah.
Yes. And we are saying, and I refer to the same authority, the Dollar Land, that you ought not to look at what the parties are called, what they are referred to, and so on. You have to look at the substance of the agreement. Because notwithstanding that Greenfield was referred to as a developer, one can be a developer under various types of relationship. Not because Greenfield was called a developer did it necessarily mean that the only relationship under which he could develop was that of principal and agent.
You said the Court of Appeal are wrong there because Clause 2C
Yes.
does involve such a covenant.
Yes. And well, yes, on clause 2C, yes, so they clearly provides the obligation for the appellants to transfer to the end user or the nominees of Greenfield, which in this case would have been the end purchasers, the ultimate purchasers. So this clause must be read in the context of the agreement, contemplating inter alia that the lands were being developed and sold in parcels to various end users. And that is what 2C was there, the purpose of 2C. And then I go on to refer to why this was done, insofar as the board feels it is able to invoke the commercial common sense principles. It was clearly to obviate an unnecessary expense in the form of substantial stamp duties under Section 44 of the Stamp Duty Act. And then the Court of Appeal at paragraph 50, so at 50 they erred in considering terminology such as development and developers and so on. I just address the board and your lordships on that issue. And
Is this quite a common arrangement to avoid stamp duty, structuring a transaction?
yeah, for a large development type arrangement, yes, it would normally be, you would normally structure it that way. Because these lands are undeveloped, which carry even a higher stamp duty. There are no exemptions and so on.
Right.
So if you buy, undeveloped lands, you pay 7% in stamp duty for this of the total figure. And these lands were, as the board can see, as your lordships can see, very substantial lands.
You quote in your written case the relevant provision of the stamp duty
Yes.
legislation.
Yes.
Was this explained to the Court of Appeal that this was a device to arrange a sale to the sub-purchasers while avoiding a conveyance to the developer in order to save stamp duty, or was that something that you raised
Yes.
simply with us?
Yes, it was raised in our submissions, and also the evidence of Maria Donowa.
Yes.
She explained that is why that was done in that particular way.
Because I don't think...
That's page 154.
I don't think the Court of Appeal really faces up to that, do they?
No, they did not address that. It's on page 154, just for reference. That's paragraph 10 of the witness statement of Maria Donowa, in which she... So insofar as the Court of Appeal relied on use of terminology, development, developers, and so on. I refer to Cousins, Hardy, MR. It is quite plain by the mere use of a well-known legal phrase. You cannot convert a transaction into that which you attempt to describe by that phrase. Perhaps the commonest instance of such a use, which has come before the courts in many cases, arise in this way. Two parties enter into a transaction and in effect say, it is hereby declared that there is no partnership between us. Quote. The court pays no regard to that. The court looks at the transaction. So we are saying they were wrong to do that. But even if you were looking at terminology, then you have to give more weight, we are saying, to 6b. Because 6b, clause 6b, refers to balance of the purchase price. And that is not simply an issue of naming a party. That is a substantive clause and an obligation. So then you must give more weight to those words in 6b, balance of the purchase price, in determining what the true relationship is. Further again at paragraph 50, the Court of Appeal again makes reference to a purported absence of any obligation to transfer title to Greenfield. And in this regard, the Justice of Appeal who delivered on behalf of the Court of Appeal states, nor does it purport to require the appellant as owners of the said land to effect any such transfer to Greenfield or its nominees at any point in time. The only obligation to transfer title is on the part of the appellants, and it is an obligation to transfer the developed lands to persons who purchase them. See clause 3F. So the Court of Appeal referred to clause 3F, but again omitted to address clause 2C, which creates the obligation on the appellant to transfer the lands to the end users. And again we say, if the intention of the parties in the 2000, and that's an error in the case, in our written case it says 2008, I'm reading from page 317, 317, subparagraph N. Towards the end of that paragraph, our Lords will see further, if the intention of the parties to the 2008 agreement was to constitute Greenfield an agent. Now that 2008 ought to be 2006, so that was an error. But so what we are saying here is, if the intention of the parties to the 2006 agreement was to constitute Greenfield an agent, then clause 2C would not have been necessary. You would not have had a clause where the appellants have to transfer to the end users, because the agent would have been acting on behalf of the appellants, and that is an obligation they would have had as a matter of law. Further again at paragraph 50, it is the Court of Appeal inferred that because of the ability of Greenfield to pay for the lands was contingent on the payment of the sale of development lands, the 2006 agreement could not be a sale agreement. And we say that that reasoning was flawed for several reasons, and I've already submitted to the board. And this is a material error on the part of the Court of Appeal, because they assume that all the payment for the land was to come from the sales. But as we have seen, that is not the case. what was coming from the sales is a percentage of the profit under the compensation scheme. The payment of the lands was to come directly from Greenfield, and Greenfield remained under an obligation to do so. But in the alternative, we say that even if the purchase price was to be paid from sales, that would not in itself mean that there is no relationship of principal and agency. And the transaction, as we have put it, would still accord with commercial common sense. And I say this in the context of normal commercial relationships where a vendor of goods, for example, supplies goods to you and gives you, for example, a 30-day credit period. And the reason for that credit period, it is anticipated that in that period, those goods would be sold. He would get money and be able to pay his supplier. And that is not such a relationship, is not a relationship of principal and agent. So when you look at it in a commercial context, commercial common sense, it still does not imply that because monies were to come from the sales, that is necessarily a relationship of principal and agent existing. And then I address clause 3F, and well, we've already addressed that point, clause 3F, and where the Court of Appeal found 3F was actual authority, conferred actual authority, and as I said, and it was authority derived from the contract or an obligation.
Well,
Yes.
authority derived from the contract only in respect that there was a sale of the sale of the interest already,
Yes.
which put the developer, on your case, in a position to do what he wished with the property.
Yes, and as my lord indicated, even further, he was under an obligation to sell those lands.
Yes, I mean, if on your case,
Yes.
you could strike out clause 3 and just found on
Yes.
clause 2 and clause 6 to say that there was a sale.
Yes, yes.
Clause 3 means what it says on the tin. It's the developer's obligations.
Yes.
Yes.
So, and so based on what I have submitted, it is our position that the 2006 development agreement did not constitute Greenfield an agent of the appellants, and based on that, we did not see the need to go further. So my lords may have seen that we have abandoned the issue of whether the developer acted outside the scope of the authority. And therefore, if we've abandoned that, ratification is no longer an issue. Unless my lords wish to hear me on any issue, those are my respectful submissions.
Could I just ask you this? It appears from the Court of Appeal's judgment, and I'm looking in particular at paragraph 49, that they were impressed by the fact that the 2006 agreement did not state in terms, in the way one might normally expect, that this was a contract of sale.
Yes.
Is there anything you'd like to say about that?
Yes, so they looked at, one of the things they looked at, it was not couched in what you have as a standard sale of land agreement. But our position is it need not necessarily be. It's a matter for agreement between the parties, and standard sale conditions can be varied by agreement between the parties. So notwithstanding you don't have your 10% down on balance in 90 days and so on, it doesn't mean it's not a sale agreement, because it's a matter for parties if they wish to vary those standard terms and have specific terms regarding the sale and payments and so on.
Are there any formal requirements in Trinidadian law concerning contracts for the sale of land?
Only that it need be in writing.
Only that it be in writing,
Yes.
there's nothing else.
Yes.
So you say
Yeah.
you've done enough here.
Yes.
Yes.
And well, as a matter of law, not particular to Trinidad, but you would have to have certain things, names of the parties, the purchase price, and the description of the land. Other than that, there are no other particular requirements.
And you say you have all the components of that contract?
Yes.
Yes, thank you.
But even if we do not, it doesn't change the fact that it was a sale, the relationship was a sale of land agreement. It may have been a badly drafted one, but it's certainly not one of principal and agent.
No.
Yes.
But you're submitting to us that there is no formality required that is missed out in this contract for it to be interpreted as a sale of land.
No formal.
Thank you.
Yes, just one short question. Could you just look at the 2008 agreement?
Yes.
The standard one, which we've been given. I'm looking at it, page 4 of the 15-page example that we were given. Clause 1, property and price.
Yes.
The vendor will sell as beneficial owner, and the purchaser will purchase. My dim recollection of English unregistered conveyancing tells me that in England the words as beneficial owner simply mean that certain covenants for title are being given,
Yes.
rather than assertion that they're the beneficial owner. Is that the same in Trinidad?
Yes, a covenant for title under section 27.
Thank you.
1A of the Conveyancing Act.
That's very helpful indeed. Thank you.
Thank you. Well, unless any of my colleagues wish to ask. No. Thank you very much for your assistance in this matter. The board will take time to consider its judgment. And thank also those who assisted. We thank also those who assisted you in the preparation of this case. I would like an explanation as to why the key documents bundle was late. But beyond that, the board thanks you for your presentation.
Thank you very much.
The board will now adjourn.